Hey everybody, it's Professor Diffley, Philosophy 255. This is Chapter 8, Lecture Video 5, the last video for this chapter. So, where we left off last time, we were about to talk about privileged communications. And so what are privileged communications? These are the things, relate to privacy, where your client tells you something in confidence, right? So you have keep it confidential. Now, these are things, you probably heard this before. It's like when you talk to a lawyer, a doctor, those sorts of things. They have to respect your privacy and keep things confidential. The thing about this is a couple things. One, these are protected by statute. So this is the law, right? It varies state to state, but what we'll focus on here is, there are protections in every single state. There are some differences in each one. Here, though, let's just look at Massachusetts. Here's the Mass General laws. And this is the actual law there. Real important thing here is that, excuse me, any court proceedings or anything, preliminary there too, the client has the privilege of refusing to disclose or prevent witnesses from disclosing any communications, however made or wherever made, between the client and their licensed social worker. And so the client, this is an important thing, your client has this privilege, right? So it's up to them to decide what can and cannot be shared, which is again, consistent with everything we've seen so far. So remember, this is really only your client can waive this, and that's really the biggest thing here. Privilege can be waived. The client can say, no, it's fine. The social worker can testify, can tell them about what I said, but it is up to the client to waive this in court. You can't go in and say, yes, I know it's supposed to be confidential, but I'm waiving the privilege. Only the client can do this. And they'll do that in consultation with their attorney, that sort of thing. So we've just got to be aware that until that waiver is given, you have to keep these privileged communications privileged and confidential. It can be pierced in certain situations. What do we mean by pierced is that the court can override and overrule the client, but don't worry about that. That's actually much more on the legal side there, and that's not a decision you would be making on your own. There would be attorneys involved. So really don't, just know it can be pierced in certain situations, but most importantly, the privilege can be waived, but only by the client. Let's just finish up here talking about informed consent. We've talked about this before throughout the course because it is a significant thing, but you can see here at the end, towards the end of the book, there is an entire chapter on it. So what is informed consent? Informed consent is, and I'm just going to read the description here, knowledgeable and voluntary agreement by a client to undergo intervention, that's in accord with their client's values and preferences. Again, we've talked about this multiple times. What this is really saying is that the client has to have all the information available so that they can make a decision, right? They can consent to treatment. They can consent to the by picking an option, that sort of thing. But again, consent from a patient for treatment after have been given all the information about their condition or illness. So all possible treatments that are recognized, the possible outcomes, that sort of thing. Again, this is about, if you want to connect it back to the theories we looked at here, this is very much connected to deontology, the practical imperative, where you need to have all the information before you can make a decision, right? So this, you need to be upfront and honest with them. And so what we're trying to get is the clients to have informed consent. Now, here's the thing. How does a client give consent? Here's a different ways, and this is all covered in the text too. But one of the questions, does silence equal consent? So you ask your client a question, do they consent with moving forward? It used to be the view that silence was consent, but it's not. Do not accept silence as a sign of client consent. There's lots of reasons why your client might not answer. They might nod their head, but is that good enough? I would go probably not. Because, think about it. Why would you ask a client a question and they just sort of nod, but they don't say anything? Why are they nodding? Maybe they don't understand what you're saying. They don't, maybe the language barrier is there, that sort of thing. What you want is direct consent. Direct consent is verbal or written consent, right? Where it's clear, yes, I consent, verbally or written. So Direct consent is where it's clear, it's verbal or written, yes. Tacit is when the client remains silent, and that's what we do not. So tacit consent, not acceptable. Direct consent, verbal or written, is what we're striving for here. So which one would you pick, oral or written consent? Best practice standard is written consent. Why? Because it gives document, it gives evidence. It could be reviewed, it could be used. Because if it's just verbal consent, then it can be, you could see situations where it's you say one thing, then the client says, no, I never actually gave it. Here it's in writing, it's in black and white, it can be there. Sometimes verbal consent is required, right? If it's an emergency situation, that sort of thing. So, I mean, oral is, oral verbal consent is not a throwaway. It can work, but, a best practice, always get it in writing. And that is true for everything. Always get it in writing. Other questions here. So say past consent. Does that equal present consent? So say one time you ask a client, say, hey, I need to send your confidential information to an insurance company or someone else, and they give the consent that time. Is that enough for you to be able to go ahead and do this over and over again? No. You need to be gain their informed consent every time, whenever there's disclosure of certain information, and we'll see that in a couple slides. So always get it. So once you consent one time, well, you're free to choose to not consent in the future. So just remember that. Once you give consent, that's not a blanket there. And again, that's really, does present consent confer future consent? Again, no, same idea. So you need to get consent from the client every single time through. Here's the code section. And what we're getting into here is that forms of consent, how you're going to get it from, are going to vary by client, right? If the client's not literate, they can't read, well, then if you give them a document, say, obviously that's no good because they have no idea. Or if they have language barriers, right? It could be foreign language. It could be, from what you speak, it could be a mental disability, anything. You can't, so you're going to have to tailor this to the client's comprehension level and their abilities, right? So for some clients, that's going to mean really detailed verbal explanations or having an interpreter, a translator come in. For others, sorry, I didn't mean to go ahead there. For others, it's going to be different, right? It's going to be more simple. It really is going to depend on your client. But the key takeaway here is that when you're trying to get informed consent, you need to match what works best for your client there. Again, for some that will be written, some, will be very short. They understand it. You're going to know your clients. You'll be able to read them, understand them. And so that's really what we got to know. So again, one form of consent is, and explaining it is not good for everybody. Again, think of really that one where you have an illiterate client, and a literate client. You got two clients. One can read, the other cannot. You shouldn't give them the same thing, right? That's just not fair. So that should make sense there. Informed consent when a client lacks capacity. What you need to do there is, and say the client has, remember, only courts can determine whether a client has capacity. So say it's been determined that they don't have capacity, they lack capacity, then you need to get permission from the third party, whoever's been appointed to make decisions for them, that sort of thing. So you really just make sure that there's always going to be someone to make these decisions for them. But you want to take means to enhance their abilities, right, and make sure they're being taken care of there. Make sure the third party is acting consistently if you can, that sort of thing. But just keep in mind that consent in certain limited cases can come from a guardian ad litem, a court-appointed guardian, that sort of thing. That's really what you need to know there. One of the tricky situations here, say you have an involuntary client, someone who's committed. How do you truly get voluntary consent, informed consent from them, right? It's really difficult, because say it's court ordered, even though the client doesn't want to go through it. And, even in that case, you're the client could be sort of two people. It's the person, it's the courts there. But nonetheless, you still want to give the client as much information as possible, the person you're seeing, even if it's involuntary. And so again, this is 1.07D. and give them the extent of their right to refuse and what that would mean, right? So say the court orders it, they refuse to go through it. Well, that could have a significant negative impact on the client's legal proceedings, legal standing, legal situation. This one more if you're dealing with, again, committed clients who've been committed for one reason, clients who have been arrested or in prison, that sort of thing. But just keep aware of that. That this is another one there. More on informed consent. Again, just don't assume it. This is a rehash of what I have in an earlier slide. So when should consent be gained? Every time a new treatment starts, every time a new social worker takes over, and every time information is sought to be released. So to think about insurance companies, employers. So every single time this needs to be reviewed and revisited. But these are the big three. Every time there's a new treatment, every time someone else takes over, a new social worker gets involved, and every time information is sought to be released. How much information? So this is one of the tough things. Some clients may be overwhelmed, right? So if you give it to them all too much information verbally, they might get lost, overwhelmed, that sort of thing. You need to make sure they get enough information. For sometimes, too much information. It's a very delicate balancing act and is really going to be tailored to the individual client. There's some, the textbook does a good job of talking about this there, but really, again, it's going to be different for every client, as I said. So disclosure. So what should the client know? What's being disclosed? To whom the info will be given? What's the purpose of the giving out the info? What are the consequences of it? And what are the consequences if they refuse it? Right. So this is what we're going for here. Make sure you're checking off these. What is being disclosed? Who it's going to, for what purpose, what are the consequences of if it's given, and if they fail to disclose it. This is really and now these are the big 5 that you're going for there. Now the levels of information will depend, again, on the client's abilities. And what I mean by abilities there, again, are they literate? Do they have mental disability? That sort of thing. Again, it needs to be done in clear and understandable manner. Again, as I said, this will vary from client to client. For some, you need to give one explanation and they get it. For others, you need to do multiple ones. This should make sense in that idea. Again, needs to be voluntary, not coerced. What do we mean by not coerced? Is that you're not threatening. Say, hey, if you don't do this, I'm going to do something bad about you there, right? That's what we're talking. It's not the same as say, hey, if you don't do this, there could be negative consequences, right? You won't get your benefits. That's not coercion. Why? Because it's just reality, right? That's the law. That's the standard. What we're talking about is saying client really doesn't want to do it, and you threaten them with some punishment that's not, really there by the law, So it needs to be voluntary. And again, coercion means forced illegally, right? In an improper manner. Again, just because they're going to lose a benefit because their insurance or something like that, that's not coercion. That's not what we're going for. Competence, again, we've talked about this, only can be determined by a court of law. So really, that's all you need to know about that one. You can take a look at exemplar 8.3 in the book there. You also got, the thing is, say a client says, yeah, go ahead and do whatever you think is best. That's a tricky situation, right? Because what kind of consent? They just said, yeah, go ahead and do whatever. I would be uncomfortable with that. I would start slowly. I wouldn't overwhelm them. I'd try to talk back. Sometimes it's going to take multiple sessions and multiple talks to them, but you can see this in 8.3 there. And that is really the last of the slides. Remember, again, competence can only be determined by a court of law, and you still have to make a judgment time to time, but really leave it up to the courts there. But yeah, that is it for this chapter. As always, if you have questions, just email me, let me know. Happy to talk with you. All right, this is the end of chapter 8. Thank you.